Was adjourned. That brings us to item 3, case number 359988, people of the state of Michigan versus Ali Hussein Kejjan. And we just have defense counsel endorse. Counsel, please, once you get started, help us out with the pronunciation of your client's name.
Yes.
I didn't know that did that. Thank you for educating me on that, Michelle.
My pleasure. If you sat back there, you would know because there's a sign.
Very good.
Good morning. May it please this honorable court. Alona Sharon on behalf of the appellant Ali Kejjan. Your honors, I've been here enough times to know that the panel is always very well educated as to the facts and the law. I would just like to take a few minutes to address some points that are in the prosecutor's brief. And then of course, if your honors have any questions, I'll be happy to answer those. I really am going to focus on the first issue in my brief having to do with the lack of interpreter past the first couple appearances for Mr. Kejjan. I actually switch between the two pronunciations. What is undisputed in this case, right, is that there are two valid signed court orders requiring interpretation services for the defendant throughout the pendency of the case. It provides for payment for these services. These orders exist, they're in the court file, nobody contests their existence. And nobody objects to their existence when they're signed at the time that they're entered into the court file. What we have is that the defendant had court-appointed counsel. He then substitutes in retained counsel who is ignorant to the existence of these orders and who never took the opportunity to review the court file. And so goes through trial, sentencing, the entire pretrial, completely ignorant of the fact that these orders exist and that the court has provided for an interpreter for the defendant. Once these orders have been entered under the applicable court rule, two things have to happen for the defendant to stop having an interpreter at his court appearances throughout trial and throughout sentencing. Those two things are a knowing and voluntary waiver of his right to the interpreter and a finding of the trial court that the interpreter is not needed. Two things. What happens in this court, in this case, at the conclusion of the Ginther hearing, I don't want to be too strong, but it's almost offensive to me because the trial court recognizes the court rule and decides to just ignore it. He recognizes that there are two valid orders. He is fully aware of the court rule because it was briefed for him. He looks at the court rule and says, it's almost unbelievable, and it's at page 25 of the brief. He makes a finding that Mr. Kejjan, or the defendant, never made an affirmative request for an interpreter. He says, what this court has learned throughout this matter is that at no time did defendant affirmatively ask for an interpreter. And I'll be totally honest with you, when I heard that, my reaction in my head was like, I'm sorry, what? There are two signed court orders. How did that happen? It happened because somebody requested an interpreter on behalf of this defendant. And for a trial court to say that a defendant hasn't requested something when his attorney has done so on his behalf is remarkable to me. An attorney is an agent for his client. That request is preserved when an attorney makes a request on behalf of his client, and that law is in footnote 11. And so the trial court judge says, well, one could assume that the earlier court and the earlier attorney, referring to Attorney Watson, decided an interpreter was necessary because of Mr. Kejjan's nationality. So let's go to the next step and find out if it was necessary. So by doing that, not only does the trial court ignore the testimony of Attorney Watson, who made very clear that it wasn't just his nationality, but it was his engagement with Mr. Kejjan. It was his continuing feeling at the time of the Ginther hearing, had I remained as his attorney, I would not have gone through trial without an interpreter. That would not have been a prudent decision, in my opinion. It wasn't just based on his nationality.
Can I ask counsel?
Yes.
He had several evaluations done, and no one did it with an interpreter.
That he had an evaluation for competency.
Exactly, which
Yes.
is fairly complicated. And he did it all in English, correct?
You are correct.
He spoke to the investigator, the detective, at the very beginning. I think we saw the video, which lasted about 10 minutes.
Yes, a
And
portion
he
of it.
spoke in very fluent English. I think I only caught 2 verb tense exchanges that I think common people make, English speakers make, as opposed to people who have English as a second language. And throughout so much of that, he did very well. And I understand the whole thing behind the orders. And being a trial court judge, sometimes you're stuck when the court rules are not followed because they don't always have a clear indication as to what should happen, right? And had anyone raised the question prior to trial or during the pretrial phases, it would have been very easy to get an interpreter in there. But no one raised it. No one.
And so if I may respond. Right, so I've seen the video as well, and I understand, and no one knows what happened during that competency evaluation, right? I mean, we don't have a camera into how easy it was for him to communicate, and we certainly
You could imagine that if the competency evaluator had issues, they would have said, "We can't continue here. We need to get an interpreter." I've had cases like that before. You've had cases like that before, but it was all done completely in English.
right. So what I would say to
Counsel, can I just interrupt in furtherance of Judge Feeney's question? Didn't his own retained counsel testify at the Ginther hearing that his client understood him and understood English? I mean, someone that he paid to represent him testified this client understood his attorney. I mean, didn't he testify to that?
So to respond to both of.
Did he testify to that? Yes or no? That's my question.
I think that is a slight misrepresentation of his testimony, of Attorney Blackman's testimony. Can I ask, where do I look to make eye contact with Judge Jansen? Is there somewhere?
Well, that's fine. You can just look at the bench right before
Okay.
you.
I'm sorry.
So I thought that's what he said. He understood me. That's why I, didn't do anything.
So
I mean, that's a pretty telling.
so if I could just address Judge Jansen's questions first.
Yeah, please.
Okay, so if you look at the testimony from the Ginther hearing, specifically, Attorney Blackman testified, first of all, I would highlight that Attorney Blackman at sentencing specifically addressed the trial court and said that English was a bad language for Mr. Kejjan. That's at pages 13 and 14 of the sentencing transcript. He also told the court that Mr. Kejjan did not understand a lot of English. That's also at page 13 of the sentencing transcript. And he was confronted with that at the Ginther hearing. He also testified at the Ginther hearing that he always tried to talk to Mr. Kejjan in plain language. And if he had to use a more sophisticated word, he probably told him what that word meant. He also testified that he would describe certain language that he felt needed explanation, or if Mr. Kejjan requested explanation, he would explain. He acknowledged.
Well, I mean, that's true of somebody who speaks English and isn't familiar with the criminal justice system. I mean, some of the concepts, obviously, the defendant was not familiar with, just like any defendant, whether English was his first or second language. That's not extraordinarily unusual.
Sure.
But he did testify the defendant understood him after he explained things and maybe elaborated on certain definitions. I mean, this is retained counsel. This is someone they're paying directly to represent the defendant.
Right, and I think that makes it all the more offensive, respectfully. But if I may continue,
I
Mr.
think it gives. I think it just gives more weight that the defendant actually did understand English in light of all the other supporting evidence that he did understand.
Mr. Blackman also acknowledged that there were times that Mr. Kejjan requested and required explanation of various words. And
Well,
this-
yes, so what? I mean, that's common. This is a criminal proceeding, and he shouldn't be too familiar with all the different legalese of a criminal proceeding. That's true of any defendant.
So respectfully, Judge Jansen, what I would respond to that is that taking the position that, well, that's fine because Mr. Kejjan could ask him for explanation when meeting with his counsel. Even if I were to accept that, okay, how do we handle that in real time when trial is going on? How do we protect the defendant? Because it sounds like, respectfully, Your Honor, that you are accepting that he probably did have some trouble understanding and that he did require additional explanation, because that's certainly what Judge Blackman's testimony reflects at pages 31 through 32 of the Ginther hearing, and
I
additionally.
think he meant Mr. Blackman's testimony, not Judge Blackman.
I apologize. Mr. Blackman's testimony at the Ginther hearing at pages 31, 32, 38, 33, all where he indicates that Mr. Kejjan required additional explanation of various words and that Mr. Blackman would explain to him what he needed. And that was fine. And I would say fine. When I'm meeting with a client, if I need, like Mr. Kejjan, and there is the need for additional explanation because of a language barrier, maybe it's okay that I can break it down into simpler language. How is that happening in the middle of a trial when I'm up at the podium conducting cross-examination and he's sitting there without anybody to explain anything to him?
Or an expert explaining DNA evidence.
Exactly. So let's not forget that there is one part of this of the ability to consult with counsel, and then there is critical stages of a defendant's proceedings, including trial and sentencing, when he is sitting there with an attorney who he cannot fully communicate with. So to take respectfully the position that his counsel says he was able to communicate with him, there are limitations to that in this Ginther testimony. Well,
Counsel, I mean, there's limitations for any defendant who may be uneducated or have, not finished school and not understand things. I mean, your argument can be applied to multiple defendants who just aren't sophisticated defendants. They haven't been through the system. They don't understand everything. But that's typical. I mean, clearly your client spoke English at different evaluation events. His attorney says he understood him. I mean, what you're saying is maybe he needed further clarification during the trial. Yes, but that's not unusual. I mean, I wouldn't expect defendants to understand everything that's going on when they haven't been regular defendants and through the system. I mean, that's not a requirement.
the difference is, Your Honor, is that in Mr. Kejjan's case, there are two valid court orders requiring that he have an interpreter throughout
Yes,
this case.
I know that's in the record. I got that.
Did both of those orders come from the district court?
No, one was signed by a district court judge and one was signed by a circuit court judge. I believe the circuit court judge was Judge Jamo, but both orders are attached, Your Honor, and have been filed with the court for the court's review.
But not by the trial judge, the judge who handled the trial.
That is correct. And
Counsel, I think we understand your argument.
I've got one more question.
yes, Your Honor.
In terms of a workable standard here, because the argument that he's participating without any visible difficulty, it's hard for the trial court until they're confronted with the fact that, wait, there's these orders in the record to say, well, nobody's requested this. I didn't know that this person needed this, and they've been interacting throughout. You're not saying that anyone who, the issue here really is the orders. It's not the fact that English is not his first language. It's that we have these orders in place that at some point identified the need for a translator, and the trial court did not go through the process of making the waiver and then making findings about his ability to understand English.
Correct, because he has the right to the interpreter once the request has been made and it has been ordered. And you have testimony from Mr. Kejjan that the lack of an interpreter also weighed on his decision of whether or not he was going to testify, because he was terrified of testifying without an interpreter. He was worried that he wouldn't understand, and he was worried that he would misspeak. That's straight from the Ginther hearing testimony.
Fair to say this would be a different landscape if those two orders had not been entered. Everything else exactly the same, his ability to understand English exactly the same throughout. But if those orders had not been put in place and he makes it to the end and says, hey, wait a minute, at the end of this case, I didn't actually understand what was going on, would you still be asking for the same relief?
I think then, so at that point, Your Honor, it would be, I think, most likely a straight and effective claim, and the court would have to make a finding if he in fact needed an interpreter. But I would just like to add this, Judge Hood. I would very respectfully disagree with the characterization that he just has a little bit of difficulty understanding. I think the testimony, right, these orders don't come out of thin air. They come out of the fact that his first attorney believed it was necessary. I mean,
Let me ask you a question. In your exchanges and representation of the defendant, did you have an interpreter available?
but I did repeatedly have to
Did you
explain.
have an interpreter when you were during your representation of this defendant? That's my question.
I did not.
Okay, thank you. I think we understand your position.
But in my offer of proof, I did submit to the court that in almost every exchange with Mr. Kejjan, even using simple words, and one of the first examples I had in my first conversation with him was using the word strategy. He had no idea what that word meant. And not only has he had difficulty in understanding me, but there are times where he says things to me that I have no idea what he's saying. And he has to rephrase it because his English at times is so broken. So I strongly object to the characterization that his English is just fine, and that there has to.
Counsel, you've made this argument. I think your
Thank you.
time has expired, quite frankly.
Thank you for your very diplomatic request for me to shut up and sit down. Thank you, Your Honors.
The case is submitted.